Conversations in Civics. I'm Dr. Terri Susan Fine. Joining me for this conversation on civil rights is Jan Leisher. Jan, before we jump into this meaty topic, tell us a little bit about yourself.
Well, I'm a 7th and 8th grade gifted social studies teacher at Bridgewater Middle School, which is in Winter Garden.
And is there anything else that you do for your professional life?
Well, I like to stay busy with lots of learning, and recently I've been involved with the Florida Joint Center for Citizenship, and it's been really wonderful in helping me to hone my skills in constitutional issues.
Jan, where would you like to start with this conversation?
Well, I think the best place to start would be a little bit of review of what the difference between civil liberties and civil rights is.
Both of them share the term civil, which means citizen. Civil liberties means freedoms, and we understand that to mean the privileges of citizenship, things that a person may do if they want to do, or protections that a person would have if they were accused of violating the laws. We call that the rights of the accused. Those are civil liberties. Civil rights are the protection that government guarantees to you just for being a citizen. It guarantees your right to do something. And the government must take a proactive stance on guaranteeing you your civil rights. So voting rights is the best known of all civil rights. The government must actively protect your right to vote if you're a citizen.
Do both the national level government and the state level government have a right or have the responsibility of guaranteeing these civil liberties and civil rights?
I really like the way you phrased that question, because you said, do the federal government and the state government have the opportunity and the responsibility?
Yes.
And yet at the same time, they also have to work together. The 14th Amendment, which is where our focal point for civil rights is, defines citizenship. All persons born or naturalized in the United States are citizens of the United States and the state wherein they reside. No state shall deny any citizen of the United States their life, their liberty, without due process of law. They may not take any of those away. So what that means is that once you are a citizen of the United States, which is defined in the 14th Amendment, then no state, through its own laws, can take away from you your civil rights, either through state law or by preventing you from enjoying your rights as a citizen under federal law. So they're separate, and they also have to work together, the state serving the federal government in that capacity.
Well, you said the 14th Amendment, and as I'm trying to remember, that would have been one of the amendments that came after the Civil War.
Yes.
and dealt a lot with the rights of those who had been newly emancipated?
Absolutely. After the Civil War, there were 3 amendments added to the Constitution. The 13th Amendment, which took away slavery or involuntary servitude. The 14th Amendment, which among other things defined citizenship, that's in Section 1. And then the 15th Amendment, which said that the right to vote cannot be denied on the basis of race or previous condition of servitude. So essentially, we think of the 13th, 14th, and 15th Amendments as the civil rights amendments, because before a person can be a citizen, they can't be a slave. Once they're a citizen, they then enjoy the rights and protections of citizenship, such as the right to vote. So they really are understood in the order that they were added to the Constitution. 1865 for number 13, 1868 for number 14, 1870 for number 15.
Well, as I'm hearing you say this, it seems to me that the courts would have had to have been involved in a lot of the decisions that were going to be necessary to make sure that all states were adhering to these new constitutional amendments.
Right, absolutely. That particularly when we come to the 14th Amendment includes something that we call the Equal Protection Clause. And that has been interpreted by so many different courts over the years and interpreted in different ways. And this is why this subject is so important, because the 14th Amendment has been in place since 1868, yet the Supreme Court in 1896, in a case called Plessy versus Ferguson, they took that same language of the 14th Amendment and said that states had the right, if they wanted, to have laws that created separate but equal accommodations based on race. In 1954, so just 58 years later, the 14th Amendment had not been changed by a single word, and yet a different Supreme Court said that separate but equal is inherently unequal when we're talking about public education in the case of Brown versus Board of Education in 1954. So we have this guarantee of equal protection to citizens as guaranteed in the 14th Amendment. But the citizens of 1896, that didn't mean that separate but equal was unconstitutional, but in 1954, for students, it did.
I guess the other thing I'm thinking about is the civil rights movement, which I hear you kind of talking about, even though perhaps you didn't say it directly.
Yes.
And I'm also wondering, you know, how the national legislature was also involved in key parts of guaranteeing civil rights to all citizens.
And I appreciate that you're making distinction between the different branches of government, right? We often talk about the courts when it comes to civil rights, and after the courts were involved in Plessy versus Ferguson, and then the courts were involved in Brown versus Board of Education, and a series of cases that came after that interpreting and reinterpreting the 14th Amendment relative to public education. In the mid-1960s, after the civil rights movement was getting very, very active under the leadership of Martin Luther King, that the Congress passed and President Lyndon Johnson signed the Civil Rights Act. The Civil Rights Act, in many ways, picked up where Brown versus Board of Education left off. Brown versus Board of Education says separate but equal is inherently unequal in public education. So that means that for students who are going to school, because the law says that they have to go to school, they are protected from being separated based on race. But Brown versus Board did not deal with those people who were citizens and had the right to vote. So when we're talking about persons who are not in a compulsory situation such as school, that's where the civil rights movement picked up. So the civil rights movement, many people say, officially started on December 1st, 1955, the day that Rosa Parks was arrested in Montgomery, Alabama, for refusing to give up her seat on a bus. Martin Luther King, at age 26, gave his first political speech 5 days later to try to convince the residents, the African American residents of Montgomery, Alabama, to give up the segregated bus system until things got better. And that boycott lasted for over a year. People walked to church, they walked to work, they walked to the grocery, they set up private taxi systems, they did anything that they could to not use the city bus system. And with these victories of the Montgomery bus boycott, when the Supreme Court said that you could not have segregated seating on the city buses, other types of civil rights activity emerged from that. So, for example, there were 4 students at North Carolina A&T University in Greensboro, North Carolina, who decided that even though Woolworths was a private company, that they did not have the right to deny them the right to sit at the lunch counter. The rule was, in the Woolworths, was that you could order food for takeout, but you were not allowed to sit at the lunch counter. So you can see that these different populations living in different communities in the South, they became emboldened by their newly found opportunities to experience life as citizens in the United States. In 1963, in August, we see Martin Luther King delivering his I Have a Dream speech. And there he wasn't interested in special rights based on race. He was interested in equality, so much so that at some point race would no longer be something that people even noticed about other people. So by 1964, the Civil Rights Act was a natural progression because we had seen the Supreme Court being involved, we had seen local and state governments being involved, and then there was pressure placed on Congress, pressure placed on President Johnson to take action. What many people don't realize is that when John F. Kennedy was running for president in 1960, he was a strong advocate for a Civil Rights Act. But in the time that he was president, he was not able to enact a Civil Rights Act. So in taking this inheritance in many ways because of Kennedy's assassination, Lyndon Johnson pushed very hard for the Civil Rights Act, because as we have to realize, Kennedy was assassinated 50 weeks, less than 1 year, before the 1964 election. So if Johnson wanted to run for president, he had very little time to prove that he could get along well with this Congress and to get something done. So Johnson then moved towards the Civil Rights Act in 1964, and then, just like the natural progression of the 13th, 14th, and 15th Amendment, once the guarantees of citizenship were put into this legislation, then came the guarantees of voting in the Voting Rights Act. Because the 15th Amendment is relatively vague. It says that you cannot deny somebody the right to vote based on their race. But what does that mean when it comes to things like registration? You're not being denied the right to vote. You might be denied the right to register. In the state of Mississippi, before the 1965 Voting Rights Act, less than 1% of all African American citizens had registered to vote.
Wow.
Right? So it's just a natural progression. Supreme Court, state and local governments, Congress, and the President.
I'm seeing a lot of connections here, and I guess my next question is there a connection between the Civil Rights Movement and other social movements?
Absolutely. We see, for example, that in 1966 and 1967, we see two of the largest women's rights organizations forming. The National Organization of Women was formed in 1966, and then in 1967 was a National Women's Political Caucus. And so we saw the women's rights movement being pushed forward into the late 1960s. And then one of the highlights of the women's rights movement was in 1972, when Congress voted positively to ratify the Equal Rights Amendment. Now, the Equal Rights Amendment was not ratified eventually to become part of the Constitution, but nonetheless, in terms of a focal point in the women's rights movement, that was the fight for Equal Rights Amendment and what that might mean. But there was so much debate and discussion over what equal rights would mean relative to, does that mean that women would have to be conscripted if there was another draft? What does that mean for certain kinds of laws that might have given women some preference? Would those go away? And so there were other kinds of debates going on there. We've been talking so much about post-Civil War issues. We talked about that 100 years before, but interestingly enough, in 1856, there was a very, very interesting Supreme Court case. It was called Dred Scott versus Sanford, right?
Yes.
Yeah. Do you think we should talk about that a little bit? Do you think that's relevant
I think
here?
that's a wonderful place to give some historical perspective to this discussion.
Yeah, I mean, because 1856, by 9 years before the end of the Civil War, by 12 years before the definition of citizenship, Dred Scott dealt with a slave who wanted his freedom. He had lived in a free territory for several years. He was owned by a Navy surgeon who traveled around. But what's interesting about that is that when Dred Scott went to ask for his freedom, the Supreme Court, as involved as they have been, as we've been talking about, decided to uninvolve themselves, saying that because Dred Scott was not a citizen, he didn't even have a right to be in front of the U.S. Supreme Court. So I thought it was just really an interesting notion that we've been talking about how the Supreme Court got involved by saying separate but equal, then saying not separate but equal in school, and then we see the Congress getting involved in state and local governments. But we also have to look at the flip side, which is before there was a Civil War, the Supreme Court also had decided to be uninvolved in this debate as well. So we see all kinds of interesting opportunities for discussion. There's been so much to talk about when we talk about civil rights, and I'm so sorry that we're out of time. It's been such an interesting discussion, and Jan, thank you so much for joining me today. We've been talking about civil rights and how they differ from civil liberties, and how civil rights are recognized by both state and federal governments. And that's Conversations in Civics. I'm Dr. Terri Susan Fine.